In the United States, about 1% of the population is in prison. That means for every 100 people, one person is locked up behind bars. This is by far the largest percentage of the population of any nation that's incarcerated. In comparison, Russia holds one person in prison for every 200 people. China, a country we criticize for violation of human rights, has one person in prison for every 1,000 people. In fact, there are more people in prison in the United States than there are people in prison in China, even though China has a population of 1.4 billion. Most people are in prison in the United States because of drug charges. If someone committed the same drug crime for which they go to prison in the US in Europe, they would likely not even be charged with a crime, much less go to prison. Those convicted of drug crimes are generally non-violent and made model criminals. This has led to the growth of the private prison industry that seeks to house non-violent criminals, often convicted of drug crimes. There are two kinds of criminal charges in the US criminal system: misdemeanors and felonies. Misdemeanors are crimes punishable by 1 year or less in county prison. Felonies are punishable by 1 year or more in the state prison. One convicted of a felony can serve a life sentence or may even face a death penalty. I vehemently object to the death penalty, regardless of the underlying reason for the conviction. Every crime, be it a misdemeanor or a felony, has certain elements. To convict a criminal, the prosecutor must prove every element of the crime beyond a reasonable doubt. For the defense to succeed, the defense must show at least one element of the crime is not satisfied. Prosecutors often convict criminals without proving every element of the crime. The reason is that some defense lawyers do not understand the elements of the crime. As an example, let's look at the crime of burglary and its three elements. They are element 1, breaking and entering; element 2, into a building or occupied structure; and element 3, with the intent to commit a crime once inside. Once the defendant has turned the knob and entered the property of a stranger without permission, he has completed the first two elements of the crime. He needs not take a hammer and break the door down. Element 3 is usually an issue with the intent to commit a crime once inside. The prosecution must prove the defendant intended to commit a crime before he entered. There are two important points here. Point 1, the defendant must have the intent to commit a crime before he enters, but need not actually commit a crime once inside. So if the defendant intends to commit a crime and enters the property, he has completed the crime of burglary and can be convicted, even if he commits no crime once inside. Point 2, on the flip side, one can only be convicted of the crime of burglary if the prosecution can prove he formed the intent before entering. If the defendant formed the intent after entering the property, the defendant can be convicted of burglary. This is a simplified example of how prosecutors and defense attorneys prosecute and defend the accused. The standard of proof in criminal trials is beyond reasonable doubt. Beyond reasonable doubt means that when a reasonable person looks at the facts of the case, there exists no reasonable explanation for the facts except that the defendant has committed the crime and is guilty of the crime. High quality representation means creating doubts in the mind of the jurors. If doubt does affect a reasonable person's belief that the defendant is guilty, the jury is not satisfied beyond a reasonable doubt and defendant walks free. An arraignment is a hearing where a defendant in a criminal matter is given notice of the criminal charges against him and asked to enter a plea. The general plea is not guilty, guilty, or no contest. If defendant pleads not guilty, which is the most common plea, the judge sets bail and schedules a preliminary hearing. Since arraignment is a notice, no new charges may be added after arraignment. To add new charges, the prosecution must go to the grand jury. One of the earliest stages of a criminal proceeding is a preliminary hearing or a prelim. It is a hearing before a judge to determine if there is enough evidence to hold a defendant to answer to a criminal charge. The standard in a prelim is very low. The prosecution has to prove two things. Number one, it is more likely than not that a crime was committed. And number two, more likely than not that the person charged has committed the crime. A prelim is an important hearing, however, because a criminal defense attorney can question police and prosecution witnesses. It is through this questioning that a competent criminal defense attorney can point to discrepancies and poke hole in the prosecution case at trial. Some criminal cases are resolved through plea bargaining. In a plea bargain, the defendant agrees to plead guilty to a lesser or a different charge, and the prosecution drops some of the charges against the defendant. The main reason the accused pleads guilty to a crime is the fear of undeserved greater punishment after losing a trial. This is understandable, since the defendant is facing the full power of a government hell-bent on conviction. When the evidence is very strong against the defendant, the plea is of benefit, however. It is a way to lessen punishment when negotiated by a defense attorney committed to fighting for a client and ready to go to trial. In criminal prosecution, there is always two versions of the truth, the accused version and the police version. A competent defense attorney will have the client version be the one accepted by the judge or a jury. Police and prosecutions are honorable men and dedicated to eradicating crimes. In pursuit of that goal, they are willing to go to any length to convict a criminal. Some go as far as twisting the facts and even lie. A competent defense attorney will uncover the truth by investigating the facts and balancing it against testimony offered by the police and prosecution witnesses. The best advice on all criminal matters is this: do not talk to the police or the prosecutors. Under the Fifth Amendment, you need not talk to the police. Many defendants violate this caveat and engage in discussion with the police to clear things up and go home. This never happens. When talking to the police, the accused often provide the police with all the information necessary to convict him. When speaking to the police, remember, they are expert at extracting information to convict you. They do this all day long, every day. Do not talk to the police or the prosecutor. The most daunting problem facing those who are convicted of a crime, be it a misdemeanor or a felony, is a criminal record that is left behind. Once convicted of a crime, the criminal record follows the criminal despite the fact that he has paid his debt to the society. This is far-reaching consequence, especially when seeking employment. The job market is shut to those who have been convicted of a crime. This is perhaps the main reason you need to find the criminal charge tooth and nail. I'm attorney David Sheehan. My goal is to keep criminal defendants out of prison. I work with a team of lawyers I'm honored to call my colleagues. We work as a team. My colleagues share my views presented in this video. We are dedicated to criminal defense, helping you stay out of prison and walk free.